The violation notice included a photograph of my own living room, taken through my front window at what the timestamp confirmed was 9:47 in the evening, showing my curtains open just enough to reveal a sliver of lamplight and the corner of my television, and cited it as evidence of a window treatment consistency violation, under a policy I had never once heard of in the 4 years I'd lived in Thistledown Grove. I remember standing in my kitchen holding that letter, staring at a photograph someone had taken of the inside of my own home at night without my knowledge, and feeling a very specific, very cold kind of anger that took a long time to fully understand the shape of. My name is Priyanka Delacroix Winfield. I live in Thistledown Grove, a community of about 330 homes, with my husband Bartholomew and our two teenagers, Aditi and Rowan. For 4 years, our HOA had been run by a fairly hands-off board that mostly concerned itself with landscaping and the occasional dispute over holiday decorations, the standard, mildly annoying but generally harmless texture of suburban community governance. That changed about 8 months before this story starts, when a woman named Waynetta Kilbride ran for board president and won, largely uncontested, on a platform she described at the candidate forum as a commitment to restoring visual harmony to our streets, language that, in hindsight, none of us took nearly seriously enough. Waynetta's early tenure looked, at first, like fairly standard aggressive HOA enforcement, citations for slightly overgrown hedges, a warning letter about a basketball hoop positioned too close to the street, the usual petty texture that most communities eventually experience under a board president who takes the job a little too seriously. What none of us understood yet, and what I only discovered myself after receiving that photograph of my own living room, was that Waynetta had developed a specific, deeply personal fixation on what she called window presentation, the visible interior of homes as seen from the street through front-facing windows, and that she had apparently been documenting this fixation for months, using a level of surveillance that none of us had any reason to suspect. I want to walk you through exactly how I discovered the scope of what she'd been doing, because the initial violation notice, unsettling as it was on its own, turned out to be only the very beginning of a much larger problem. After receiving that photograph of my living room, I called the HOA management office, genuinely more confused than angry in that first conversation, asking how a photograph of the inside of my house had come to exist at all, since as far as I knew, nobody from the HOA had ever requested to enter or photograph my property. The woman at the management office told me that all violation photographs were taken by board members during routine community walkthroughs, and that questions about the specific photography methods used would need to go through the board directly. I requested a meeting with Waynetta, which she scheduled for the following week, and in that meeting, sitting across from her at a small table in the clubhouse office, I asked her directly how she had obtained a clear photograph of my living room interior at nearly 10 o'clock at night. Her answer, delivered with a calm confidence that I found genuinely unsettling in hindsight, was that she used a high-resolution zoom camera during evening walks specifically to document what she called window treatment compliance, explaining that our governing declaration included a general provision requiring homeowners to maintain visually consistent exterior presentation, language she interpreted as extending to what was visible through a window from the public street, regardless of whether curtains were fully closed or not. I want to be very clear about something, because I think it matters enormously for understanding how absurd this justification actually was. Our governing declaration's exterior presentation clause, which I went home and reread in full that same evening, was written, based on the surrounding context, to address things like exterior paint colors, visible clutter on porches, and unapproved exterior modifications, the kind of standard aesthetic language found in nearly every HOA declaration in the country. Nowhere in that clause, or anywhere else in our declaration, was there any provision addressing the interior visibility of a home through its own windows, curtains, or blinds, a category of restriction that, as I would soon learn from an attorney, would raise serious privacy law concerns even if it had been explicitly written into the document, which it was not. I asked Waynetta how many homes she had photographed this way. She told me, without any apparent hesitation or discomfort, that she conducted these walkthroughs several evenings a week and had been doing so since shortly after taking office, a timeline that meant, by my own quick mental math sitting in that clubhouse office, she had potentially been photographing the interiors of homes throughout our entire community, at night, without anyone's knowledge or consent, for the better part of 8 months. I left that meeting deeply unsettled, and I want to be honest that my first instinct, much like I've heard from friends who have dealt with similarly invasive situations, was simply to close my curtains completely every single evening and hope this would resolve itself quietly. But the more I thought about it over the following days, the more I understood that a private board member photographing the interiors of homes without consent, at night, through windows, was not a problem I could simply curtain my way out of. This was almost certainly a serious violation of state privacy law, and if she had genuinely been doing this to dozens of homes over 8 months, there were very likely a significant number of neighbors who had no idea it had ever happened to them at all, since presumably most of these photographs simply sat in some HOA file unless they happened to result in a citation like mine. I called my sister, Farrukh's wife. Actually, no, I want to correct that, my own sister, Conception de Lacroix, who works as a paralegal specializing in privacy and surveillance law, a specialty that turned out to be extraordinarily useful given the exact situation I now found myself in. Conception listened to the entire story, asked several sharp, specific questions about the exact wording of Waynetta's explanation, and then told me something that reframed the entire situation. Priyanka, she said, most states have specific statutes addressing exactly this kind of thing, sometimes called voyeurism or unlawful surveillance statutes, and they typically don't require someone to have physically entered your property to violate them. If she's using a zoom lens specifically to capture interior details of your home that wouldn't be visible to an ordinary passerby without that equipment, especially at night when interior lighting makes rooms considerably more visible than they'd be during daytime, that can absolutely cross the line into unlawful surveillance depending on your state's specific statute language, regardless of what the HOA declaration says about window treatments. I want to walk you through the research, Conception, and I did over the following 2 weeks, because it ended up mattering enormously for how this entire situation was eventually resolved. Our state, it turned out, had a specific statute addressing exactly this kind of conduct, prohibiting the use of any device to capture images of another person inside a private dwelling, in a location where they have a reasonable expectation of privacy, without consent, with specific language addressing telephoto or zoom equipment used to overcome the natural privacy protection that distance and standard window coverings would otherwise provide. The statute carried both civil and potential criminal penalties, and critically, per Conception's reading, applied regardless of whether the photograph was taken from a public street or private property, since the relevant question under the statute was whether the subject retained a reasonable expectation of privacy inside their own home, not where the person taking the photograph happened to be standing. This isn't really an HOA dispute anymore, Conception told me. This is a potential criminal matter, and I think, before you do anything else, we need to figure out exactly how many people this has happened to, because if it's just you, that's one kind of case. If it's dozens of families, that's something considerably more serious, and it's the kind of pattern that a prosecutor is going to take very seriously. That question, how many other families had been photographed without their knowledge, is what led me to my neighbor Farah Enkemelu Boyd 3 doors down, a woman who happened to work in IT security for a regional bank, and had, as it turned out, a very particular set of skills that were about to become extraordinarily relevant to this entire situation. When I told Farah what had happened, over coffee on her back porch one afternoon, she went quiet for a long moment, and then said something that changed the entire direction of this investigation. Priyanka, she said, if Waynetta's been doing evening walks with a zoom camera for 8 months, capturing time-stamped images good enough to use as violation evidence, there's a very good chance she's not just deleting those photos after each citation. People like this almost always keep records, either out of habit or because they think of it as documentation protecting themselves if a homeowner disputes a citation later. I think we need to find out whether she's storing this somewhere, and if she is, whether there's a way to see exactly how extensive this actually is. What Farah discovered over the following 3 weeks, through entirely legal means involving a public records request and a piece of information that came from an unexpected and almost accidental source during a completely unrelated HOA committee meeting, revealed a scope to Waynetta's surveillance that went far beyond anything conception or I had initially imagined, stretching back not 8 months, but nearly 2 full years, across a device and storage system that, once we understood how it actually worked, gave us exactly the leverage needed to end this permanently. The discovery that broke this case wide open came from an entirely unrelated HOA landscaping committee meeting that Farah happened to attend a few weeks into our investigation, where Waynetta, apparently trying to justify a proposed increase to the community's technology budget, mentioned in passing that the board maintained a compliance documentation archive hosted on a cloud storage account the HOA had set up specifically for her violation photography, a detail she offered casually. Clearly not realizing how significant it would become once Farah, sitting quietly in the back of that meeting, heard it. Farah's professional background in IT security meant she understood immediately what this likely meant, that Waynetta had probably been uploading her photographs directly to a shared cloud folder as she took them, rather than storing them only on a personal device, and that if this folder had been set up through the HOA's own management account rather than Waynetta's personal one, which seemed likely given that she described it as an HOA resource during a budget discussion. It might actually be something the HOA's own board, and by extension the full membership, had a legitimate right to access and review. Conception helped me draft a formal records request to the HOA management company, citing our state's specific provisions around association members' rights to review board records and documentation related to enforcement actions, and requesting complete access to any and all photographic evidence maintained in connection with violation notices issued over the preceding 2 years. This kind of request, Conception explained, was something HOA members in most states have a legal right to make regardless of how uncomfortable it might be for the board, since violation documentation is generally considered part of the association's official records rather than any individual board member's private property. Management company, to their credit, complied within the required response window, and what arrived was a shared folder link containing, by Farah's count once she'd finished cataloging it, just over 1,100 individual photographs, spanning nearly 2 full years, going back considerably further than Waynetta's 8-month claim, meaning she had, in fact, been engaging in this practice under the previous board president as well, likely as an ordinary resident rather than in any official capacity, before ever running for the board position that gave her the additional cover of calling it official compliance work. Farah spent the better part of a weekend cataloging that folder, and what she found was staggering in scope. Photographs of at least 94 different homes throughout Thistledown Grove, many of them taken repeatedly across multiple evenings, timestamps ranging from early evening well past midnight in a significant number of cases, images that, based on Farah's professional assessment of the metadata embedded in the files, had clearly been captured using a telephoto lens capable of resolving interior details that would have been completely invisible to an ordinary passerby glancing at a house from the street. I want to tell you about the specific moment this stopped feeling like a personal grievance and became something we understood we had an obligation to bring to the entire community. Buried in that folder, among the images tagged with what appeared to be Waynetta's own informal filing system, were several dozen photographs of families in various states of undress, visible through windows they had reasonably assumed provided adequate privacy given the distance and angle from the public street, along with a smaller subset of images that included children, a discovery that made both Conception and Farah go completely silent for a long moment before Conception said, quietly, that this needed to go to law enforcement immediately, not just the HOA board. We filed a formal police report the following morning, providing the folder access along with Farah's cataloging documentation and Conception's legal analysis of how the images likely violated our state's unlawful surveillance statute. The detective assigned to the case, a careful, thorough investigator named Sergeant Adiz Ferreira-Holt, told us during our initial interview that the scope and duration of what we'd found, combined with the clear evidence of premeditated use of specialized Zoom equipment specifically to overcome natural privacy protections, made this one of the more serious cases of its kind she'd handled in years, and that she intended to pursue it aggressively. I want to walk you through what happened over the following months, because this case moved through both the criminal system and our own community's governance structure simultaneously, and both mattered for how it ultimately resolved. On the HOA side, we requested an emergency special meeting of the full membership, and Conception helped us prepare a presentation that was, deliberately, far more restrained than the full scope of what Farah had actually found, since both the ongoing police investigation and basic decency toward the affected families meant we were not going to publicly display or describe the most invasive photographs in front of the entire community. Instead, we presented the pattern itself, the number of homes affected, the time span involved, the fact that photographs had been taken well outside any legitimate compliance walkthrough hours, and the confirmation that this practice predated Waynetta's board presidency entirely. The reaction in that clubhouse, when we laid out the scope, 94 homes, nearly 2 years, thousands of photographs stored in a folder she'd apparently forgotten could be legally requested by any member, was unlike anything I'd personally witnessed at an HOA meeting before. Several neighbors, upon realizing their own homes were very likely among the 94, left the meeting visibly shaken, understanding for the first time that private moments inside their own homes had potentially been documented and stored for years without their knowledge. Waynetta, present at that meeting, attempted initially to characterize the entire situation as an overzealous but well-intentioned compliance effort, language that fell apart almost immediately once a neighbor near the front, a father whose own home had been confirmed among the photographed properties, stood up and asked her directly whether compliance documentation typically involved photographing people through their windows at midnight. She did not have an answer for that question, and the vote to remove her from the board that night was immediate and unanimous, minus her own abstention, along with a formal resolution directing the HOA's attorney to fully cooperate with the ongoing police investigation, and to review and permanently delete the entire photo archive following the conclusion of that investigation, ensuring it could never be misused further by anyone. The criminal case concluded about 7 months later. Facing overwhelming documented evidence spanning nearly 2 years, clear metadata establishing deliberate use of specialized equipment, and testimony from Sergeant Ferreira-Holt's investigation establishing a pattern that went well beyond any plausible claim of accidental or incidental photography, Waynetta accepted a plea agreement on charges related to unlawful surveillance, receiving a sentence that included jail time, an extended term of probation, mandatory registration under a relevant offender statute given the images involving minors that had been discovered, and a permanent restraining order barring her from Thistledown Grove entirely. I want to be honest about something, because I think it matters for anyone reading this who might be dealing with something similar, even on a smaller scale. This entire process was exhausting, and at times deeply upsetting in a way that went well beyond the kind of frustrating but ultimately survivable HOA disputes I'd heard about from friends over the years, disputes over pool floats or fences or parking spots. Finding out that someone had been documenting the private interior of my own home and dozens of my neighbors' homes for 2 years is not something that resolves into a tidy, satisfying feeling of justice quite the same way a simple property dispute might. What it resolved into instead was something closer to relief and a very specific, hard-won kind of vigilance that I know several of my neighbors still carry with them, checking their curtains a little more carefully now, not out of compliance with any HOA standard, but simply out of an awareness that privacy, once you understand how easily it can be violated by someone you trusted, is not something you take for granted again. The new board, elected about 2 months after Waynetta's removal, formally amended our governing declaration to explicitly prohibit any form of photography or recording of a home's interior from any location, public or private, without the express written consent of the resident, closing permanently the exact loophole Waynetta had exploited by claiming her declaration interpretation gave her some kind of implicit authority she had never actually possessed. If there's a lesson in this story, I think it's something Conception said to me near the very end of the whole ordeal, sitting at my kitchen table reviewing the final settlement documents together. She said that the most dangerous kind of overreach in situations like this rarely announces itself clearly. It hides behind official-sounding language, compliance documentation, community standards, routine walkthroughs, words designed specifically to make an invasive, sometimes genuinely criminal act sound like nothing more than diligent governance. The moment you actually ask the simple, direct question underneath that language, how exactly was this obtained, and what gives you the right, the entire structure tends to collapse considerably faster than the person hiding behind it ever expects. We asked, and it turns out that one uncomfortable photograph of my own living room, one careful sister with the right legal background, and one neighbor with exactly the right professional skills to trace where 2 years of stolen privacy had quietly been stored, were more than enough to make sure Waynetta Kilbride never got to photograph another window in Thistledown Grove again. Thumbnail text: SHE FILMEDUS through our own windows.